Okay, while we're waiting, I've looked at this Wadler case.
Yes, sir.
Come on up, Mr. Gilthart. Where's Mr. Wadler? We got an issue here. This is his fifth DWI. Fifth. That's a rare event in 20 years and 40 years of experience. A fifth. You got a problem, obviously. The biggest problem is the magistrate that set the bond at $8,000 is woefully too small, woefully. Obviously, the magistrate must not have known about his rich criminal history of DWIs. Or else, certainly there would have been something more. I don't even see conditions of bond here that protect the community from somebody who is charged with the fifth, who has 4 prior DWI convictions and is back with another DWI. You can't operate a 4,000-pound missile around town and not put everybody else in harm's way. Are you an alcoholic, sir?
Yes, sir, I am.
What are you doing about it?
Right now, I'm currently going to AA meetings.
Are you?
Yes, sir.
Okay. Well, you've only been arrested. This has been your arrest for DWIs date back how long?
Since my late teenage years.
46 years.
Yes.
He's also
46 years. 47. Well, 11 and 12. Yeah, it's, listen, no, we're going to say 37 years. 37 years. Is this the first time you've had treatment? Over 37 years of inebriation and
No,
criminality?
No, sir.
What have you had in the past, sir?
I have repeatedly gone back.
Well, that's not working, is it?
Yes.
Oh, you say attending AA meetings is going to do it? Well, right now, if we tested you, we're going to test positive for alcohol?
No, sir.
Okay. Or drugs?
No drugs. No.
Okay. Well, this for a fifth DWI to have a bond of just $8,000 is comical, almost comical. I mean, that's like the Three Stooges. It just doesn't make any sense. Doesn't make any sense. But I'm not criticizing the magistrate. He may not have had this kind of information at the time because you were indicted after the arrest, and he just deals with that arrest. But do you drive vehicles?
Look, currently, I'm.
You have to have an interlock device, you know.
Yes.
Okay. And I want. What do we use as a condition for alcohol monitoring?
We could do a personal device.
We usually have either a handheld device, Your Honor, or we do an interlock device. It just depends, like a car interlock where we have a handheld.
I want to know if
device.
he's drinking at any time.
That's-
Alcohol.
Yeah, we have a handheld device that they can use, Your Honor, that they just take everywhere they go.
But how do they do it, though? I mean, well, how often is that done?
It'll randomly go off.
And
We'll
then-
have to blow in it.
Then they have to blow in it.
frequently throughout the
Okay,
day.
okay.
Yeah, it hits throughout the day, and
Mhm.
I'd have no objections with
Well,
going for that.
It's going to be done.
Well, I would even
I mean, this
recommend
is a fifth DWI. My God, it's preposterous, you know, and that's what juries don't find it amusing. All right, this is most serious.
Yeah.
Yes, you're going to have what is it called?
It's a handheld monitoring device.
I know, but I need a terms used legally so that he is held accountable.
Is it the
If
same-
it's just a handheld device to blow in, that's not going to be enough.
Or you can do like the handheld. It depends, but yeah, either one works because they both do alcohol.
All right, as a condition, an additional condition of bond, you're going to have to blow into a monitoring device in a regular fashion, and the probation office will discuss. There's a Scram device, we call it Scram, but there's something else out there too, but it has to be something that you work through the probation office with that tests you regularly, because I don't want a hint of alcohol showing up. This is far too overwhelming of a consistent pattern of misconduct. I'm sorry.
The Scram device is it monitors them 24 hours a day. So I mean, that would probably be better too.
Okay, all right.
So a Scram?
That's gonna be ordered. You've got 24 hours to get that done, to get that and start on that. And, okay, so who is monitoring the device somewhere at some location? And who monitors, and how do they alert someone? And do we have to tell them who to alert if he fails a test, so that we know he failed the test? See, that's what's the feedback? How does that work?
I believe Johnny's does Scram devices, Your Honor, and usually,
We use him a lot, but I've never met the man, I don't think. And so I don't,
when a test comes back positive or anything like that, they usually would call us and tell us that it's positive, or they would send us a report at that point.
once again, he's on a pre-trial bond, and that can work, that monitoring can work through you, the probation office? He's not on probation for anything right now.
No,
I don't know if we have the authority to do that. It's gotta be maybe somebody else, huh?
I don't know if maybe the court can monitor it, or if in that capacity, or we've.
They'll usually email us.
Yeah.
If they're.
The bonding people, right?
Yes.
Because they're the ones that are held accountable
Yes.
to making sure that he follows, and that the bond conditions and that failed conditions are reported timely. Okay. Also, before getting back, I want to test him just to make sure. Thank you.
Yes, sir.
Just, we're going to test you to make sure that there's nothing in your system. Like you say, but
Well, I'm here. Do you want me to make an announcement on the case?
well, what are you going to announce? Yeah, might as well. It was indicted in October, and this occurred of last year, but it happened October in 24. It took a year to get indicted.
He just recently hired Mr. Gilthorpe.
I know, but
His first.
he could keep rehiring different people, and that doesn't mean that
He could, he wanted to.
well, on a 50 DWI, it's got my attention. It's not gonna, he can hire anybody he wants, but I'm gonna set it for trial.
Okay.
No.
Which one? Well, anyway, that's what we'll do.
We do have our discovery, and discovery has been completed, Judge.
Okay, good. All right. Yeah, I don't know what kind of, how you dispose of something like this without it being pretty severe, it would seem like. People haven't, keep an eye, I mean, it's got the attention of everybody when you have a fifth DWI, 4 prior convictions, a fifth one, people go, that's 4 too many.
Well, I've been in contact, prosecutor, and we'll see if we can come to an agreement. If not, we'll get ready for trial.
You know what's odd though? I mean, he's got an 89 conviction, a 90 conviction, and then a 95 conviction. Why wasn't that a DWI third? And then 20 years later, a 4th DWI conviction out of Chamber. Why wasn't that a DWI third?
I believe that one was out of the Chambers County case.
District Court? So he has a prior conviction, felony conviction.
Correct. I believe it.
Okay, it's showing up in paragraph 2. It doesn't show up as a separate paragraph.
It's just alleged as a prior DWI. It's not alleged as an enhancement.
Why not? Why shouldn't it be?
It's a DWI, I can't enhance it,
It's just,
It's a DWI felony, a felony DWI.
as long as it's still,
it's
if you're
still,
talking about increasing the punishment range, Judge, it can only be used to enhance
Yeah,
a
but
felony, it cannot
You,
enhance.
so you can have 10 DWIs and it's just a DWI second. Is that what you're saying? I mean,
no,
that's the
Judge,
way
it
the
would
law
just
works.
be a DWI
said-
third or more.
I'm sorry.
It would be a DWI third or more. You can't enhance the range of punishment unless he has another separate felony conviction.
That is something other than a DWI. Correct. It operates just like the theft convictions, Judge.
I understand, but he's got a prior. Okay. He's got 4 convictions here. And
They're all for DWIs.
what you're saying is on this DWI second or third rather, out of Chambers County, 2 of those must have been used to make that final conviction, which leaves just 1 prior left
That's why,
arithmetically.
that's
So you
why,
can't get a third because there's only 2 of them have already been used before to make the DWI third, I guess, out of Chambers County.
Judge, unless I'm mistaken, the DWI statute itself reads that we can only enhance it if outside of a third degree felony, if the person is a repeat DWI offender, the worst we're
Third.
gonna be able to do is third degree.
Third degree.
Yeah,
You're saying even if they had 30 DWIs?
Correct.
yes, Judge, unless they had a,
I understand.
It's a very problematic.
I know it seldom comes up because seldom do people have this many, but. Yeah.
We take that into account when we make the proper offer, Judge, but we cannot,
What was the offer on this?
I don't know, Your Honor.
We don't.
Oh, there isn't even one.
Correct. There's no offer at this point.
Uh,
We're working
Yeah,
on that.
we want to check the man in the foreground. How did we do with the guy?
He's all negative.
He's good?
Yes, sir.
Great. Okay. Come on up, sir. Yes, Mr. Clark. I like success there. Nathaniel. John?
We already got a resetting, so.
Okay, in cause number 25 CR 1757, Nathaniel Clark, you are looking at a third degree felony of operating a motor vehicle while intoxicated. And that's interesting.
By comparison, this
That one's in
has other felony offenses, Judge. That's why this one's enhanced.
Just a chance
So-
because the other felonies
so
are other felonies.
You're looking at 25 to life.
Right, yes.
Yes,
all right.
Yes. This prior is not the.
It's the most serious thing. So what are we gonna do?
We already resetting, Your Honor. We already got resetting earlier.
For what?
About 2 weeks for me to go over the discovery with him to get us an answer. So,
Okay,
yeah,
okay.
yeah, 2 weeks, I think, whatever. This recently.
This doesn't look good.
May 27th, yeah, we're already reset, so. Okay.
Okay. Darren Banks, please.
Judge.
I've got one plea. There are 2 cases, one that's going to be dismissed.
no, Judge, they're both, please.
I only have, oh, so good.
Same resolution in both, but it will be completed.
I'm gonna need his stuff when he comes out.
I'm gonna change her name.
Oh, these are NTRPs. I love it.
Get
I
rid
don't
of
know
it.
how people are gonna feel about they calling
We
me.
still look at it.
Is he? Are we, or are we kicking it down the
I
road?
don't know if that's calling you.
I know he's playing, but so bad.
His girlfriend might have a problem.
Yeah.
Very much down, maybe so.
She probably was.
Around the page.
Man, there's a lot of marked outs.
I sensed somebody right behind,
Yeah.
behind me really close.
Thank you.
Down.
We got. Okay, on this, okay, it's reading enhanced to a third degree. That's third degree punishment. It's a state jail felony.
That's correct.
Correct, Judge?
Enhanced to a third degree
It was, yes.
punishment, right?
Yes, when he was put on probation for it, correct.
Okay, that's what it's because it says enhanced to third degree only. That's what we
And
got.
there's another asterisk down at the bottom that details the third degree felony punishment range.
I understand that, but there's nothing that shows this is a state jail felony.
Judge, the paperwork itself is on state jail felony paperwork, which is why the additions were made for third degree.
Okay, but what I'm going to add is state jail felony and then pick up with enhanced to third
Okay.
degree punishment. Okay, so. Can't touch the pad or else it. They'll swing. So that's why I have this little. Okay. And then we did that, good. 5, 6, 5, 4. What's it? He's going to get revoked and it's 4 years in each case?
Yes.
Correct, Judge?
To run together?
Yes.
Yes, Your Honor.
Yes.
All right, we will take this numerically, beginning with 24 CR 1654, and then we will go 24 CR 2193. These are both first amended motions to revoke probation, stating the state of Texas versus Darren Adam Banks. You or Mr. Banks?
Yes.
And you hear with your attorney and the state's attorney. Does the defendant waive a formal reading of these first amended motions to revoke probation? In each of these cases, can we proceed in summary?
Yes, Judge.
Each of these similarly state, sir, that on March 3rd, 2025 in this criminal district court of Jefferson County, Texas, you were placed on, you were sentenced to 10 years in prison, probated for 10 years for the state jail felonies of theft of material, and it looks like it must be metal of some sort, copper, in 24 CR 1654, and burglary of a building in 24 CR 2193. And in each of those state jail felonies, you were sentenced to 10 years in prison, and that was suspended, and you were placed on probation for 10 years. Is all of that true and correct for each of these two cases?
Yes.
Let's see. Was it, what's he pleading to? Is it evading arrest?
But if you want him to do different violations, we can do whichever numbers you want. I put 1 and 2, but
Well, what happened in the evading arrest or detention case? Is that pending somewhere in another court?
It's pending in misdemeanor court.
Has that been disposed of?
not to my knowledge, Judge.
Failure and the failure to ID,
Same thing, Judge.
that's,
Same offense
Okay.
state, both pending in
what do y'all
misdemeanor.
want to do? Just,
I want to plea on counts 5 and 6.
It makes no difference to us.
is
Judge.
5 good?
That's fine, Judge.
All right. Allegation, and raise your right hand. Did I already swear you in?
You did not, Judge.
Do you solemnly swear or affirm the testimony that you are going to give today during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Our Lord and is this all true and correct that in each of these two cases, you were sentenced to 10 years in prison, probated for 10 years, and those were state jail felonies enhanced though to punishment as though they were a third degree felony because of the prior convictions that you have.
So.
All of that's true and correct, sir? All right, allegation 5 in each of these motions to revoke probation, then these are first amended motions to revoke probation filed May 6th. Well, that's quick. You just got,
Yes, sir.
just, okay. Do you solemnly swear and affirm that you are waiving any additional time that you may have to prepare for this hearing? Because this was filed, these motions were filed recently, and we are having a hearing here today, which is very quickly after the motions to revoke probation, which are fine, but you have about 30, I think you have at least 30 days
10.
under the law.
10.
You have time, 10, 30, 10 or more, to prepare and talk to your lawyer and think about this. You can also waive that period of time and move forward today if you wish. If you feel like you've had enough time to think with it, you've discussed with your attorney, and you are ready to proceed today. Is that what you want to do?
Yes, sir.
Okay, are you making that decision voluntarily and after discussions with your attorney here?
Yes.
Ms. Manaldi, all right. Allegation 5 states you committed the offense of evading arrest or detention on or about March 19th, 2026, Jefferson County, Texas. And this is an allegation in each of these two motions to revoke probation. And they are allegations number 5 under the first amended portion. And these also state that these allegations of evading arrest or detention in each case, those are violations of condition 1 of your probation order, which states do not commit another crime. Is all of that true and correct?
Yes.
Are you pleading true to each of these allegations voluntarily and because those allegations are indeed true?
Yes.
Do you understand that a voluntarily and knowingly made plea true to 1 or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to the full range of punishment, which is no less than 2 nor more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true today in each of these two motions to revoke probation to allegation 5?
Yes.
I find you pleading true to allegations of violations in each of these motions to revoke probation voluntarily, knowingly, intelligently, and because they are true.
Yes.
There's an agreement that states that your probation would be revoked. You would be sentenced to 4 years in prison, and you would be given credit for all time you have served in accordance with that. Is all of that your understanding? Is that true and correct?
Yes.
Are you, are you agreeing to that voluntarily and after discussing all of this with your attorney?
Yes.
Yes.
Yes, sir.
You know, I'm looking here at what this has. I gotta change the count. If I can. I've got the funny pen.
There.
I'm going to show you what's marked in each of these cases. That states Exhibit 1. Did you sign those documents? Understand them? Discuss them with your attorney? Are the contents true and correct?
Yes.
States Exhibit 1 is tendered into evidence
No
in each case without objection admitted. Among other things, these state that if I follow this agreement, you understand you are waiving all rights of appeal. I'm going to do that in each of these cases. Anything further to add?
No,
If nothing further, I'm going to make the following findings. Then in each of these two first amended motions to revoke probation here, I find that you have pleaded true to allegation 5, which is committing the offense of evading arrest or detention on or about March 19th, 2026 in Jefferson County, Texas, which violates condition 1 of your probation order in each of these cases, which states you shall not commit an offense while on probation. Your pleading of true voluntarily, knowingly, intelligently is enough to grant these motions to revoke probation by a preponderance of the evidence or greater. These first amended motions to revoke probation are hereby granted, and your Probation is hereby revoked in each of these two cases, and in accordance with these agreements, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years in each of these cases. These sentences shall run concurrently. Is that your understanding of the plan? And that shall be carried out. Anything else?
No, yeah.
That's all. Thank
Thank
you. Yes.
Really chat.
Reagan, do you know misdemeanors are today too?
I don't think so.
Okay.
I'm not sure who's appointed on those.
I was just gonna do a memo saying it that way,
Yeah.
in case they were waiting on ours.
It's like writing wills, these all these plea agreements. Okay, two. Are done. Sounds like going to the dentist almost. Here we go. Thank you. And then we got, who do you have next?
Jalen Brown.
Brown.
She's not a plea though. She's an announcement.
Jalen Brown. All right. 25 CR 1215. Jalen Brown. She was here, what, a couple of months ago?
Yes.
In
Yes.
March?
Uh,
Okay, you're charged with this state jail felony, operating a motor vehicle while intoxicated with a child passenger. As you know, it carries with it up to 2 years in the state jail, and it's a felony offense, so gotta be careful on this. Yes.
Judge, Ms. Moore and I are working on a resolution. We're in talks about it. I need to have a detailed conversation with my client. If we could reset it for 3 weeks, that would be great.
Done. Thank you.
Let's meet Wednesday. I'm on this. It's the red, so just me. Yep. We make a reset on her. I'll have the office send you a reminder about Wednesday. And then I'll let you know.
Sounds good.
On next week.
Okay.
Once I talk.
Sounds good.
What else do you have?
Travis McBride, Judge.
Travis.
I know, I need to.
Right up here.
Fair enough. Convention.
Travis McBride.
He's a plea judge.
Travis. There you go. What about Elijah Ray?
He will be, coming to you for a resolution, Judge.
Okay. He's next.
After McBride, yes, that's correct.
Okay.
Peter will be on that.
Oh, do you
Mr. Wagner?
Yes, if you.
Yeah.
have to do your pen?
So what do we do?
I was asking for a reset.
How much time?
Whatever the court wants to give us, we'll take 90 days.
Okay, if you can give me 2 more conference.
I should leave
If you're
it alone.
asking me,
No, no, this is,
You don't have to press that one.
then that would be,
180.
Okay. Will you swear that everything?
I was fourth place in number sense in high school. No, I can do the math. I can do the math. What resetting are you asking for? For what?
For continued negotiations with the prosecutor and to review discovery. I have my written discovery. I haven't had a chance to watch the videos.
Okay, then do it. You got 3 weeks for another announcement, another one,
Judge,
which makes it.
did you finish raising the bond on that matter? Because you had made the.
What do y'all want to do?
You made the comments that this was set at 8,000.
It is
That wasn't.
atrociously low. We added
We
a
added the
scram
first-
device, and that's what I'm gonna do.
Or the handheld? Or the screen?
He said Scram. He went round back and came back to Scram.
I thought y'all agreed on that. I thought y'all
I think-
decided that was what, you need one or
We
the
can
other.
do
They
one or the
work
other.
tantamount, but it has to be done he has to have that in 24 hours.
I'll get with Johnny's and we'll get a personal device if that's satisfied.
And let's review this in 3 weeks.
That's it.
Okay?
Thank you.
Enough is enough. It's a 4,000-pound missile that we drive. It has to be driven responsibly and soberly. 5 DWIs is far too many. That's 4 too many. Actually, 5 too many, but
That makes sense.
yes, I get the resetting.
Yeah.
Mr. McBride?
Yes.
In 24 CR 769, does the defendant who is here with Ms. Minaldi waive a formal reading of this motion to revoke probation? Can we proceed in such?
Judge.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Lower your hand. In summary, this motion to revoke probation states that on October 30th, 2024, in this court, you were sentenced to 10 years in prison and that was suspended. You were placed on regular probation for the state jail felony of unauthorized use of a motor vehicle, which tells me I don't even have to look. You got some pliers here. Because a state jail felony carries with it generally up to 2 years, but it's an enhanced state jail. Let's go back to the. Yeah, you pleaded true to 2018 state jail felony of credit or debit card abuse out of Harris County, Texas. Then a 2019 unauthorized use of a motor vehicle state jail felony. 2 of those enhanced this state jail felony to a 3rd-degree felony. And there was a 2023 controlled substances state jail felony out of the court next door that you didn't even plead true to, but you have that conviction. So you have 3 prior convictions. And then this one is a 4th conviction. See what this is heading. It's mysterious. I'm going to fill in the stage, yeah. Yes. 3,
Yes, Judge.
Yes, Judge.
we're. Hold on. What happened to him in 2023? Next door in that state jail? Was it? It was a felony, so it was state jail enhanced. What did he get in there,
Let me look, Judge.
please? Do you know?
I'm looking, Judge.
So he was placed on probation after that conviction. But it had to be Could have been just a jail, but I think he was probably enhanced.
Do you know what county did you say it was from, Judge?
Jefferson, 252nd. 222-41183.
I see it.
Yes, Judge, he was given 12 months.
It's weird.
2023.
So I guess it was prosecuted as a state jail.
Yes.
Yes.
That's correct.
Well, I almost dropped that. Then. Okay, and you're swearing under oath here. I swore you in already, correct?
Yes.
And you're swearing that all of this is true and correct, that on October 30th, 2024, in this court, you were charged with a state jail felony
Yes, Your Honor.
and you pleaded guilty on that date to a state jail felony, which was enhanced because of prior state jail felony convictions
Yes, Your Honor.
to, I guess, a third degree felony punishment. And you were sentenced to 10 years in prison, probated for 10 years. And all of that is true and correct, correct?
Yes, Your Honor.
Is it number one we're going on?
Yes, Judge.
Number one states
One
that
and
you,
two.
can we just do one?
Sure.
Is it allegation number one states you committed the offense of illegal possession of drug paraphernalia on or about December 29th, 2025 in Jefferson County, Texas, which is in violation of condition 1 of your probation order, which states do not commit a crime. Is that allegation true and correct as it is stated?
Yes, Your Honor.
Are you pleading true and correct to that voluntarily and because it is true?
Yes.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation such as this. Your probation can be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you are pleading true to this violation allegation 1 voluntarily, knowingly, intelligently, and you appreciate the consequences and understand the consequences of pleading true. Race 2 and put 1. It's heartache for everybody. An agreement is reached where your probation would be revoked. You would be sentenced to 3 years in prison. Is that your understanding of the agreement? And given credit for time you have served in accordance with this case.
Sure.
If I follow this agreement, you have no right of appeal.
Yes.
States Exhibit 1, among other things, is introduced and made a part of the record for all purposes. Pre-sentence report is waived here. I'm going to follow this agreement, sir. I'm going to find, if nothing further, Mr. McBride, you have pleaded true, voluntarily, knowingly, intelligently. The allegation 1 of this motion to revoke probation in this cause number 24 CR 769. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater, which alleges you committed the offense of illegal possession of drug paraphernalia. And thus your probation is hereby revoked. And I'm following this agreement. You are hereby sent to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You understand what has happened today, sir?
Yes, Your Honor.
Is it time that you start following all the terms and conditions of probation?
Yes, Your Honor. If I may, just I want to apologize for my behavior for failing to follow guidance. I hope to take this time to be better myself. I really sincerely apologize for my
Well, just,
my failures.
yeah,
You know, I gotta do better.
just do it.
Yes, sir.
But I'm looking at Much of this is drug problems,
Yes, sir. I have.
a choice that you decided to make.
Yes, sir.
And the drugs are going to be out there.
Yes, sir.
What are you going to do about it when you
I'm gonna stay.
run into it?
I'm gonna stay focused on God. I'm going to.
Do
stay
you have
totally-
character strong enough to do that?
Yeah.
Well, then just do it.
Yes.
Then you have no excuse. Some people here
Right.
are just hopeless. You are not.
Thank you.
Do it. You have a family at home?
Yes, sir.
My God.
Yes, sir.
Do they depend upon you and rely on you?
Yes, sir.
How's that working out when you're sitting here in jail?
It's not good. Not good at all.
Well, quit being first.
Yes, sir.
What's the old saying? Our creator is first.
That's right.
Others, most importantly, our family is second. We're third.
That's right.
You got to think in life of that, not selfishly, but selflessly.
That's right.
If you care about the importance of a family, which ought to be foremost.
Yes, sir.
Okay. All right. Good luck to you.
Thank you, Your Honor.
Yes, sir.
So, right.
Is Elijah Ray
Yes, Judge.
up to bat?
Yes, he is, Judge. He will be voluntarily pleading true today.
Where is that in the
He's
bat?
in custody, Judge.
We already did Travis and Gabriel. And what else? We have Jared Gilthorpe still?
No.
No, we've got, is that it?
Yes, sir. After Mr. Wynn.
After Mr. Banks?
For the record, that would be third and two after you did. Very good sample.
Okay, we've got Elijah Ray, and after that, anybody else?
No, sir.
That's it.
Yeah.
Darren Banks taken care of, Jalen Brown taken care of.
She was reset 3 weeks, Judge, but we'll have a direction on her.
A direction,
I like
left or right?
Up or down?
it. Forward.
Yeah.
Yeah, no backwards. And we now call 23 CR 1246, the state of Texas versus Elijah Deshaun Ray. Are you Mr. Ray?
Yes, sir.
Present with Ms. Minaldi, your attorney, and the state's attorney. As you know, there is a motion to revoke probation here in front of us. And this, and can we proceed in summary? Does he wait a formal reading of this motion?
Yes, Judge, can I put a few things on the record?
Yeah, sure.
Before we begin,
Well,
please?
not.
Do you mind swearing my client in?
Raise your right hand. Do you solemnly swear or affirm any statements made during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Go
Okay,
ahead.
Elijah, you understand that you have the motion to revoke probation pending against you here in Jefferson County? And then she has to take down everything you say you're doing, but I just want to make sure that you speak loud enough for her to hear you.
Yes.
Okay, so with that motion to revoke probation, you were charged with a state jail felony and you were put on straight probation, so you already have a conviction for the offense, right? And then with this, there's kind of 3 different ways that we can resolve this, and we've talked about it.
How much time does he have, please?
You're wanting to waive your right to have a contested hearing, is that right?
Yes, ma'am.
And then we did receive an offer from the prosecutor and you're not wanting to accept that offer, is that correct?
No.
And then the other option, the kind of last option, is to voluntarily plead true to the violations and then make a case to judge for some kind of resolution.
Yes,
And
ma'am.
that's what you want to do.
Yes, ma'am.
Okay. I'm good, Judge.
All right. In summary, sir, and you've
Yes, sir.
sworn to tell the truth during this hearing.
Yes, sir.
In summary, this motion to revoke probation states that on December 19th, 2023, in this court, you were sentenced to 2 years in the state jail. That was suspended. You were placed on 5 years probation for unauthorized use of a motor vehicle. Is that true and correct?
Yes, sir.
Allegation number 1 in this motion to revoke probation states that on August 3rd of 2025 in Jefferson County, Texas, you committed the offense of burglary of a vehicle, another vehicle misuse.
Yes, sir.
You're on probation for unauthorized use of a motor vehicle. Now this alleges that you commit a burglary of a crime of burglary of a vehicle on or about August 3rd, 2023. What? 2025. I'm sorry, 2025, which would have been, let's see, about a year and a half after you were placed on probation, right?
Yes, sir.
And that was a crime committed in Jefferson County, Texas, and this states it violates condition 1 of your probation order. Your probation order states in number 1, commit no offense against the laws of the state of Texas or any other state or the United States. Burglary of a vehicle is a violation of law in the state of Texas. Do you
Yes, sir.
understand? Is that allegation true and correct as it is stated in this motion to revoke probation?
Yes, sir.
Are you pleading true to this allegation
Yes, sir.
voluntarily, knowingly, intelligently, and based upon discussions with your attorney?
Yes, sir.
Do you understand that a freely and voluntarily made and intelligently made decision to plead true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation could be revoked in this case, and you can be sentenced to up to 2 years in the state jail, from 180 days up to 2 years in the state jail.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. According to the compilation made by the coordinator, he has 68 days credit so far on this. So that's a little over 2 months. All right, there is no agreement. So let me look at one thing real quickly. The pre-sentence report. I'm going to refresh my memory here.
And Judge, I'm trying to get you a probable cause for the offense he's played.
Thank you. I mean, I think I have it.
March.
I have one. Thanks.
I think it's on the MTR. I believe it's attached.
Okay. Thank you.
The one in March, I'm not sure of that.
Is there a precedence report?
Yeah, give it a test.
Okay, I don't know that.
I have a
What is?
post sentence,
You don't have to pass it.
but not a pre-sentence for this.
Okay. No, I just have the administrative hearing, the material on the interior.
Right. In a second, I'll get it from. The PC on the new offense, it's with Ken. He just pled true to Judge. You want to read it off my computer or release it to him?
If you wouldn't mind releasing it, just so that I can look at it on the.
Sure.
All right. So I'm looking at this post-sentence report that was made in this case, prepared by the probation office, which is a very disturbing matter, which states that the police receive information that a black Chevrolet pickup truck had been stolen from an apartment complex inside of Hardin County, and just past the Hardin County line is they see the vehicle pass them. They stop. You're the driver, and there were no other occupants. There was a Ruger 9mm firearm in the driver's side floorboard. You identified yourself as Joshua Williams. That's not you, though, was it?
No, sir.
You lied right off the bat to them, right?
Yes, sir.
as though you couldn't get in any more trouble, then they asked if you were the owner. You said you were not of the vehicle. And you were picking up a family member's vehicle. That's what you told the police. There was a firearm in the vehicle. You said it's not yours, but you knew it was inside the vehicle. There's no record or driver's license of Joshua Williams that you've tried to lie about as far as your identity. So you got into all kinds of trouble. Then you finally admitted to the police when they kept, I'm sure, inferred to you, you were just committing one crime after another. The more you spoke, then you admitted you were Elijah Ray. And they found a driver's license that fit your description. So they figured out who you were. This occurred on December 23rd, but pending at that time were two misdemeanors, a failure to identify and an unlawfully carrying a weapon. I mean, all that's lying and fiddling around with weapons illegally is a mixture that is lethal. Do you understand?
Yes, sir.
And there you are. There you are in that blue outfit in the jail with all the other guys. Meanwhile, we're free.
Yes, sir.
So you're placed on 2 years state jail, sentenced to 2 years state jail, and that was probated for 5 years, and then you were fined $500 as well. So this probable cause affidavit for this new case, an auto burglary. Something about autos that you can't help but get in trouble with. The complainant stated she was out of her vehicle that was parked in the parking lot at Crazy Cajun in Beaumont and discovered that her vehicle was unlocked. Tip money was missing, about $200. And apparently, personal belongings from employees at that location or in a spot at the manager's office. So you must have taken the money from her vehicle after you took the keys from the manager's office to open the car door. Is that about right? Is that what, were you working there or something or?
Yes, sir. I was working there, but
Okay. Well,
They fired him after that, Judge.
okay. So how'd you get in her car?
car was unlocked. I never grabbed the keys or anything.
Well,
I
the
never
keys were
did.
missing.
Keys,
What are the odds of that you
The-
would walk to the unlocked door and the keys are missing?
I've never understood where that part came from because we was never even allowed in the manager's office to even grab anything
All right.
out of there.
Nonetheless,
Yes,
you
sir.
got into somebody's car and stole something that was without her permission, right?
Yes, sir.
Why would you do that? You're already in trouble for unauthorized use of a motor vehicle. Why would you tamper with a vehicle? I mean, that's the second most valuable and expensive thing we all own next to our home. So it's very expensive and that's the way people get around. Try to walk from here around Beaumont, right? You can't do it. That's why we have vehicles for convenience, but it's a very important commodity.
Yes, sir.
Why would you mess with another vehicle illegally when you're on probation? That's my question to you. Why would you do that?
This additional PC is for the misdemeanor offense. He's on probation as well, at the same time, Judge. Just so that you can get the full picture of who we're dealing with.
Okay, management was later notified of the incident, began reviewing the security footage at the business. Upon doing so, it was discovered that you had taken the keys and unlocked the vehicle. They see that on the video. You're in front of me and you're going to tell me a story differently than what is in this probable cause affidavit and expect that I'm going to be impressed with your honesty?
Sir, I've sworn.
This is all dishonest. Everything you've done here is dishonest. You're just digging a hole deeper. And you swore to God that you would be, everything you would say during the hearing would be the truth. You want perjury added to your rich criminal history?
No, sir. Am I able to speak?
Yes.
Yes, I have sworn in, and I can say again confidently that I have not taken the keys and unlocked your vehicle with the keys that they said that I have taken out of the manager's office. Next, I would like to say that yes, it looks like I am just completing offense after offense, especially with 2 vehicle crimes. But I would like to tell you that yes, I was young. Yes, I am still young. I am 21 years old. And
Wait. How old do you have to be to know you don't steal? How old do you have to? I learned that when I was in first grade. I mean, that was a commandment,
yes, sir.
but it's also the law. We all knew you stole something, you got in trouble.
Yes, sir.
And honesty versus dishonesty is right versus wrong. If you're an adult, you're having problems figuring this out?
No, sir.
Okay. Because I don't think you're dumb. I think you're a wise man. You just don't act wisely.
Yes, sir.
Let me look at this thing here. This is another problem.
So he's on misdemeanor probation that's running concurrent with this for that offense as well as an evading arrest.
When was he placed on probation for this misdemeanor? He was arrested on March 7th of 25. Then he's
April 3rd, 2025, Judge.
then he commits this on December 19th of 23. So this is all something that happened, I guess, after he was on probation.
After, I believe after he was put on the felony probation, we gave him the opportunity to continue after he committed a theft. Excuse me. He was given 1 year probation for those 2 misdemeanors, the one that you're looking at, which is the assault, family violence, and an evading arrest.
So he's arrested on March 7th, 2025. He had been on probation since December 19th of 2023.
Yes, sir.
So that's a year and 3 months.
Yes, sir. Now, for whatever reason, we only included the burglary of a vehicle in our motion to revoke probation. He could have had a motion filed over the misdemeanors that he's pled that he's on probation for as well.
What's happened to that family assault case? Is that still pending?
It's pending. It's pending as an MTRP, Judge.
Okay, I'm more concerned I see what this states. I'm more concerned though on what the probable cause affidavit reads, what he's pleaded true to on this burglary, which is of a similar fashion to unauthorized use of a motor vehicle. That again, vehicles, a person's second most valuable possession, is being treated illegally by you. You don't have appreciation to somebody else's property. And that's not appropriate. It's the same thing. It's in the same vein of thought.
Excuse me, Judge.
Yes, I'm not through. Excuse me. It's dishonest. It's dishonest. And it's hard for you to be committing and being found guilty of dishonesty, unauthorized use of a motor, then admitting to burglarizing a vehicle, which is dishonest, and then have me convinced that I'm going to believe what you say. You see, credibility is really important, and it's built over time of honesty, consistent honesty.
Yes, sir.
You're in trouble for dishonesty.
Yes, sir.
Okay. What do you have to say? Because I'm going to make a decision here.
Standing in front of you today, I know the risk that I've taken of coming in front of you asking to be reinstated, and not going back to what you said of asking the age and everything about knowing right from wrong and stealing and everything, I'd like to tell you that around those times, not only was you can say that I was in a dark place, I was hanging around the wrong people, we're hanging around bad influences. And I would like
Whose
to say
choice was that?
that was my choice.
Okay.
And I would like to tell you that I've changed every choice that I've made and I've regretted every choice that I've made. I no longer hang around those people. And I reflect on my decisions every single day, ever since I've made
It's
them.
never too late to do the right thing.
Yes, sir. And that also brings me to say that especially living in this society that we live in today,
What do you mean
people
by
might-
that? Because I live in the same society. What are you trying to say about, don't
No,
blame
the-
society
no,
for
sir,
their
no, sir,
choices?
no, sir. I'm
Okay.
talking about people that's my age, the shootings, the guns, all of that. Living in today's society, I'm liking to set an example, as in jail and outside of jail. Before I came and turned myself in, and while I'm in jail, I still speak to people my age and young people that those things aren't cool. The stuff you see on TV, the guns, the rap music, all of that stuff, it isn't cool. There's better stuff and more important things that you should be taking care of. And for me, the young lady over there, she's pregnant with my daughter. And of course, I want to be able to take care of her and I want to be able to handle our pregnancy together. And
Do you
going
have
back to what I
parents?
was saying.
You have parents. We all have parents.
Yes, sir.
You grew up, who were your parents growing up?
Only my mom. I'm adopted.
Okay. But you knew your mom as long as you've known
Yes,
a
sir.
mother? That
Yes,
was
sir.
the mom? Okay. She's still alive?
Yes, sir.
Okay. She a good lady?
Yes, sir. She's amazing. She's amazing.
Well, what was it you didn't learn from her
I
that
learned-
caused you to make these mistakes?
Going back to what I was saying.
If she's a good role model, that's what a parent is. And you're about to be a parent. The greatest gift you can give your child is having a good example, because your child's going to do what you do. If you
Yes,
are a
sir.
bad role model, don't blame them, because
Yes.
you're the direct impact to your child in the way they act and think, like your mom was, who sounds like a good lady, which meant this is inexcusable. You shouldn't even be here.
Yes, sir.
Shame on you.
I say that.
You let your mother down, much less everybody else and yourself. But all of those, hey, everybody has responsibilities, but it's how you deal with your responsibilities, responsibly or not. They're called responsibilities, but you still have to perform the verb. You have to act responsibly. Responsibility is a noun, but it turns into a verb in the way it is handled. And you haven't handled your life well, much less you've got a child on it. It's never too late, but it's just more than talk. And sir, growing up with a mom like you had, shame on you. These mistakes shouldn't have been made. You know it, but you're paying a price.
Yes, sir.
And it's just right now, it's just talking. You were on probation and now you're back for the same kind of thing. Then you're going to be held accountable. You know that.
And I would like to say that I take full responsibility for everything that I've ever done. And I always apologize.
That's what we all do, sir.
I always apologize to my mom, telling her that she's a good mother. And
Why do you keep apologizing? Why don't you start acting so that you don't need to apologize?
Yes, sir.
We all make mistakes, but you're consistent. You got to stop that, which you can do. You're talking the talk. You got to walk the walk that you talk about, which is responsible behavior. What's the state saying on this? What are you asking for?
All right, Judge, if I may, I disagree with reinstating this young man. His words are nice, but his actions speak something entirely different. He was arrested on April 10th of 2023 for 3 offenses.
I understand.
And as a result of his plea in December of 2023, he had 2 charges dismissed and he was placed on probation. Then on February 1st of 2025, he picks up 3 new charges. He is placed on probation for 2 misdemeanor offenses, and 1 was dismissed. Now he stands before you having pled true to committing a third event
Mhm.
of criminal activity and burglary of a vehicle. And even when in his recitation with you, he doesn't even accept responsibility for that. I'm fearful of what he's telling these people he says he's talking to, giving advice. And I'm certainly not going to applaud him for not using guns on these things. But my responsibility as a prosecutor in this county is to do what I can to keep our citizens safe. And I don't feel we're going to be safe with this young man running around again out there based on his track record. His words are nice, his conduct is not. I think that the probation here is 2 over 5. I made an offer was extended for him to get half of that time, which is a year state jail. I still think that's a fair resolution for what's taken place here, but I don't agree with reinstating him.
Go ahead, Ms. Manal.
And Judge,
You're lucky you have a great lawyer,
Yes.
but again, she can only work with what you've done. And that's where you don't need to be in here. You need to be out there acting responsibly. Go ahead.
And Judge, we're obviously asking for reinstatement. He has accepted that responsibility for that new burglary of a vehicle by that voluntary plea of true. And just to add some more background to that situation, he did return the money and make the victim whole again in that situation. So she's not waiting out for restitution. She was made whole again in that situation. He corrected that mistake and accepted responsibility for that mistake whenever it occurred, and he's here doing it again in front of you today. You'll note that in the motion to revoke probation, the other 3 violations that are alleged are administrative in nature. They have to do with his supervision at the probation department, but with him being here today in front of you and him speaking with you and detailing that he would be successful again on probation, he's asking for a second chance. I'm just going to echo what he has already requested and explained to you, Judge. And if that reinstatement is not to be considered, we would request that 1 year that the state has suggested, we would request that if reinstatement is not an option.
If I may, Judge?
Yeah.
The probable cause on the new offense indicates that the only reason he returned the money was he was shown the security footage that indicated that he committed the crime.
Mhm.
So it's not like he made somebody quote unquote whole. In fact, the victim in the PC says she was missing $200. He returned an amount that was less than that.
From probation, among other things, this alleges that he failed to provide verification of performing community service hours as required, and he was on probation from December until, I guess, the arrest, which occurs on or about August 3rd of 2025. So that's about a year and 7 months or so.
Correct. Yes, sir.
How much, I'm just curious on community service hours, how much did he perform?
He has performed 160 hours. He has 240 remaining.
Okay. And the substance abuse assessment that was scheduled for October of 25. Were you arrested? When were you arrested in this new case? Do you remember? He didn't attend that. I'm asking if he didn't attend this substance abuse assessment because he was in custody.
He got booked into custody on March 10th of this year.
Of this year. So he was. Okay. On this substance abuse assessment that was scheduled, he just didn't appear for it?
Correct.
Was it rescheduled then?
It was.
To when?
For multiple dates that coincide with our office visits, he just never attended the substance abuse assessment after that.
Okay. And then he's in arrears here for payments. How much in the way of payments has he made? I'm just curious about what
His
it's done.
mother made a payment on his behalf while he was incarcerated.
I'm talking about when he wasn't incarcerated. Before he was incarcerated, how much did he pay toward his fees and costs?
Prior to that, Maybe around $500.
Okay. All right, anything else to add by anybody? Anybody, you can, anything else you want to say, Mr. Ray?
About the substance abuse class, I came up to her and asked her if she could schedule me for that. She told me that I was going to get a text message about it.
Yeah.
And I never received the text message for it. And the next time I came to the meeting, I asked her what had happened with it. And she told me that it was going to be rescheduled. I've never received, I always get a text message for every single meeting that I get, and I attend every single meeting. But I've never gotten a text message about the substance abuse meeting. And that's something that I had personally asked for. And also, going back to what the prosecutor had said about saying that I'm not safe for the environment, also going back to what I said about the environment. Yes, I am trying to set an example. Yes, you told me that you can always do right. And that brings me to say that I want to set an example as in, yes, you can go down the wrong road, but that doesn't mean that you can't take the exit. You can always end up doing right. Brings me to say that I did start doing right. I started working a job to make my payments. I personally feel like
When?
that was at the end of last year, maybe around December. I was working at Sushi Masa, and then I also got a job at McDonald's at the beginning of this year. And I was gathering money to make one full payment. I personally feel like that I made payments more than $500, and also while I was
They're pretty
incarcerated
good
in
about
March.
being accurate with money. I never, as long as I've been at 20 years, I've never found that their bookkeeping was incorrect.
Yes, sir. While I was incarcerated, I had a payment made of $1,250. The community service hours, I went to a building called Some Other Place, and I would also come to the probation office and do work as in cutting grass. Basically, what I am trying to tell you right now is, yes, I've done bad things, but that doesn't mean that I'm not trying to change, and that doesn't
That's
mean that
good.
I haven't changed. And I'm here to tell you that I take full responsibility. And I'm asking you to not only trust in my words, to believe in the process that I've put myself through to become a better man, not only for myself, my mom, my girlfriend, my daughter, but also for the society and the environment that we live in. So people don't think that I'm dangerous, but I'm too bad to be around. The words that I give people younger than me and my age are words of encouragement. I always tell them to get out and do better. Get out, go and get a tweet card, get a job. There's things that are more important than the stuff that is going on right now.
All right, all of that's great. There's a big but there. When we placed you on probation, you made a promise. You signed it. It was a contract. I agree to follow all conditions imposed upon me. I know that this community supervision can be revoked for any violation. Signed. There you are. Elijah Ray. And just not long after you're placed on probation for unauthorized use of a motor vehicle, you're burglarizing a vehicle. You broke your promise. That you're being held accountable for that. You're always held accountable for your actions. And I say, great, the talk is good, but you're being held accountable for your actions that you took, which were complete failures. You committed a similar crime to what we made a big deal about. It was serious. That's what you're going to be held accountable. Now, all these good things, good, because I don't want to ever hear about you and see about you except for good things.
Yes, sir.
There, as far as this motion to revoke probation is concerned, if nothing further to add, the court finds that there is sufficient evidence supporting this motion to revoke probation to grant it by preponderance of the evidence or greater, as allegation 1 is proven true beyond a reasonable doubt, as the defendant has admitted, to committing burglary of a vehicle on or about August 3rd, 2025 in Jefferson County, Texas. This is a violation of condition 1 of his probation order, which states, don't commit another crime. Thus, I find that to be true. Your probation is hereby revoked. You were sentenced to 2 years in the state jail. That was suspended. You were placed on regular probation for 5 years. Your probation having been revoked, this court has already found you guilty when beyond a reasonable doubt of this state jail felony of unauthorized use of a motor vehicle when we placed you on probation. You having now violated your probation is revoked. The court sentences you to confinement in the state jail for a period of 1 year. And you will be given credit for all time you have served. You're going to be held responsible and accountable. And hopefully all your talk is going to result in better actions than you have taken up to now. It's just talk. All that's good talk, but I hear it all the time. That's not what gets rewarded. What gets rewarded is the actions that you take. That's what speaks louder than just talk. You understand what has happened.
Yes, sir.
Get this behind you and be a responsible family leader and a citizen. You're capable of doing that, I believe. That's what disappoints me. You didn't, you failed, and you're better than that. But again, we're judged by the actions we make. Do better. And then because you're capable. That's what frustrates me. Some people are come before me. I feel there's just no hope or very little hope. I think more of that. I think you're better than that. But standing before me and what you've done, that's not indicating it. So just do it. You're capable. Do it. Just don't talk about it. You got responsibilities that are about to begin with your family. All right. Anything else?
No, Judge.
That is all. We're in recess on this. Thank you. Good luck. Sir. Anything else? We're in recess. Here is this. Thank you, ma'am. Already.
The courtroom grew tense as the judge addressed the defendant's fifth DWI charge, calling it a serious danger to public safety. During the hearing, the defendant admitted to decades of alcoholism and past treatment attempts, while the judge questioned whether those efforts had been effective. The exchange highlighted the difficult balance between accountability, rehabilitation, and protecting the community. Thanks.